Please, a warm welcome for Mr. Ian Runkle.
Okay, well, that sort of cuts out the portion where I usually introduce myself, but I'm having the weird experience these days of walking into rooms and people know who I am, which is something I never really expected. But so one of the things people sort of ask me about is, how do you get into firearms law? Like, how does that happen? Because if you look around law schools, most people are not super keen on firearms in general, and there's, so people are like, did you grow up with guns? What's the deal there? And I really didn't. I can tell you that my mom was not big on firearms at all, and so I didn't spend a lot of time with them. My dad used to be, and then he'd sort of fallen off, but I'd gone plinking a few times with a 22. He had an old AR-7, if you remember those things. They're not the greatest in terms of accuracy, but they're a fun little... So I remembered, I'd enjoyed plinking with those. And then I went to law school. And everyone's trying to figure out what they want to do in law school. And, I had no idea. I kind of thought I wanted to do criminal law. But law school is basically designed to be incredibly stressful, because law is incredibly stressful, and they figure that if you can survive teachers, then you can survive judges. That's kind of the basic idea. So you kind of need to have something to keep your sanity, and most law students pick drinking. It's a very popular hobby. I kind of figured it was a little early to start on alcoholism. It's a popular way to exit the profession, but I thought maybe I should give it a few years before I go in that direction. So I remembered that I enjoyed target shooting. So I went and got my firearms license, and the first thing I thought was, how do I not end my career with this right off? Because there's a case that everybody sort of gets to read about a law student who managed to get an impaired driving charge and never became a lawyer as a result. And I was thinking, okay, I better know the rules. There can't be that many. So I started reading up on it, and my first thought was, I do not understand anything. I am a bad law student because I don't get this. So I kept reading because I was like, I gotta figure this out. I mean, I'm gonna be a lawyer. I should be able to figure out something this simple. And what had occurred to me as I went is that the reason why I couldn't understand it is because it makes no sense, and because, quite frankly, in a lot of cases, the courts haven't figured it out. There's a whole bunch of areas in firearms and weapons law where you have two entirely different philosophies, both of which are still being argued in lines of court, where they appear to be completely unaware of the other side sort of existing. It's really weird. And I thought, this is what I want to do, because this is an area that was just fascinating. And so I sort of dug into it and have been continuing to do it. It's an area that is deeply frustrating, because a lot of people have notions that the law should be their friend, and often the law isn't if you are a gun owner. That's just the way things are. And the courts range from sympathetic to entirely hostile when you get into firearm issues. I've had a judge quite literally tell me that if she could, she would take guns away from every single person, period. Meanwhile, I'm there arguing that my client is a hunter and maybe shouldn't be prevented from hunting. So that was a wonderful thing to hear, the judge saying, my personal opinion is to take away every gun. The good news on that one is that I think she realized what she said and didn't want to get appealed. So my client got to keep his guns, which was the right call in that case. So this is an area that there's a lot of confusion on. And so because of that, I started on Facebook. And Facebook is a weird place to try to get legal information out, because most of what's on Facebook is not information. But I was giving it a go. So I was sort of posting just legal thoughts. And so people ask how I got started on YouTube, which was somebody in my comments kept saying, you need to make YouTube videos. More people will see these, more people will sort of be able to digest them. And I thought, I am a shy and awkward person. Nobody wants to see this. But the guy wouldn't stop. Like I kept saying, like, this is not gonna happen. And he kept saying, you gotta try. So then our government, and I forget what the first video was, but it was something about our government's grand plans of firearm bans. So I went, okay, I guess I better make a video. And I figured it would fail. And what I didn't realize was just how many people out there who own guns were in the same position I was as a law student, going, what is the deal with these rules? Because unfortunately, despite my efforts, that first video did not fail. I had a whole bunch of interest in it. My wife was going, what is with your phone? Because I literally posted that video just before we went on a camping trip, because I figured otherwise I would take it down out of, you know, shyness and so forth, and my phone would not stop ringing or stop sort of going because people were posting comments and so forth. So that's kind of how I get into this, but it's a weird place to be because there's a lot of poor information out there about firearms that I try to correct. There's a lot of persistent myths, and that's within the gun community too. The number of times I've seen people say, you know what you gotta do? You've gotta get a guitar case to put your gun in. And I'm going, that sounds like a great idea, except here's a case that specifically says that you can't from the Supreme Court. And people go, oh, it's the Supreme Court, what do they know? I'm going, not much, but they still run things. And I mean, that's a frustrating case. People say, how can this be the case? Because I will get arrested if I walk out of my Toronto apartment with a shotgun over my back. And I go, well, they make a bunch of assumptions about what guns are like, and they may not be accurate, but they're what we're stuck with. So that's, you know, we end up with these situations and people get charged over them. I've seen people get charged because either they didn't know the laws, or the other thing is there are police who watch my channel, and I love hearing that. You know, and there's one guy, he occasionally sends me messages. Every time I talk about the police on my channel, he sends me a message to let me know I'm wrong, because I'm often critical of the police. But this guy, you know, every time I say something, he'll send a message, and I'm just like, this guy's one of my favorite viewers, even though he would probably not be happy to see me if we ran into each other in an elevator or wherever, because at least he's hopefully learning things. The number of situations I've seen where people get charged improperly is unfortunately quite high. I've seen people charged for possessing what the police took to be a firearm, notwithstanding the fact that it was welded solid. And by welded solid, I don't mean like just to the CFO standards. I mean this thing was basically a brick. And they said, well, it looks like a gun, so that's good enough for us, which is not the law. So that guy spent a night in custody while I was working on getting him out. I've seen people who were charged for having a firearm that was loaded with something that says 𝐂𝐂𝐅𝐿 on the stamp. So, and if you're not familiar, 𝐂𝐂𝐅𝐿, of course, is a big manufacturer of snap caps, which are not ammunition. And I'm going, you know, you can pull the trigger on that all day and it's not going to fire. It's not a loaded gun. And the officer says, well, we'll see you at trial. That was a fun trial. Didn't actually get to trial because the expert sort of went, what? But these are the problems we face. We can at any point get arrested for confusion or lack of understanding. So I kind of feel that it's important that we try to get this out. Meanwhile, we have a government that feels that it's important to do the opposite, because right now a lot of the policies that they're pushing are being pushed through a pattern of disinformation and misinformation. Everyone remembers that giant list of guns that they've had to back away from, that they wanted to hammer through in C21. their giant ban list. Well, I mean, I can forgive people if you didn't read it cover to cover because it was long. I have, I think, read books that had fewer characters than that list. But one of the things that they were saying quite openly and quite repeatedly was they were saying, listen, all we're doing is we're just putting the rules about 10,000 joules and about, those other things that they'd pushed through. They were saying, oh, we're just putting those into Bill C-21. And that was a lie. I'd like to say that it was wrong, but I don't think that they can possibly be that wrong. I think that that was just straight up deception. And the reason why I say that is because of the structure of it. They would say all firearms that shoot a projectile of over 10,000 joules, including, and then they listed things that included the Ruger number 1. Now, if you're not familiar with that particular platform, it's chambered in everything from like 22 LR all the way up to you can hunt rhinos with this. Because of course, it's just a sort of good platform that you can use for all sorts of things. It's a single shot gun, which, is not really high up on the list of concerns normally, but they said all, things that shoot over 10,000 joules, including. Now, this is a very common legal phrasing, and you'll see this if you want to see examples of just how this is used. Look at your local bylaws. If you live in a city, you will probably have a local bylaw that says that you are not allowed to keep livestock in the city. Just about every city's got one because they don't want people having cows in their front yard. But usually they'll say something like, you shall not keep livestock, including cows, sheep, ducks, chickens, bees, and you're going, wait a minute, bees? And the reason why they put that in there is because once they say livestock including bees, that means that for the purposes of that bylaw, bees are livestock. Notwithstanding the fact that you would normally say no. That's just the legal structure. And so they say, no, that this only means anything that shoots over 10,000 joules. No, once you put the Ruger number 1 there as a specific example, that includes all Ruger number 1s. Chambered in 22, chambered in whatever, it's all included. Now, I find it very difficult to imagine that the teams of lawyers that they have working on this had never seen a bylaw in their life, or never seen one of the very common sort of structures of how you phrase a law. So when they say, oh, this is what we mean, and they suddenly mean it to mean something completely different than everywhere else, I just don't believe them. But they're hoping you don't understand the difference because they tried to push that very hard. And so that's why I think that some of what I do is important, because I can stand up and go, hey, wait a minute, this isn't accurate, this isn't true. And we're seeing a lot of that, unfortunately. There's a lot of bills being pushed forward where we see that they say one thing and then they turn around and do another. We've got Bill C-11 talking about managing the internet. And the reason why they want to manage the internet is because they've got good control over sort of the established mainstream Canadian news organizations, but they have very poor control over random guy with a YouTube channel. Random guy with a YouTube channel can say what they like and is not subject to editorial control of people who go to their fundraisers. I have not been to one of their fundraisers, I will admit that. So, but they said that this isn't going to manage user content. And now we've got the CRTC talking about how it's going to manage user content. It took literally like 2 weeks from this thing being passed to completely undermining the messaging on that that's been the case the whole time. Because the messaging on it has not been honest. This is what we face, is that we've got people who are pushing for a lot of these restrictions and don't understand the current laws. I have had people say, listen, we need Bill C-21 because you shouldn't be able to buy a gun without a license. And I mean, you can buy a gun without a license here in Canada. You just also have to be a drug dealer to do it. But for the people in this room, I'm guessing everyone's got a license and has for decades. It's, you know, this has been the situation for as long as I've been alive. And so when we've got people who say, wait a minute, you need a, you know, you should have to have a license to buy a gun, I go, but that's already the law, and C-21 isn't going to do anything about it. They get really, really surprised, though, when I say, well, what C-21 would let you do is your ex who doesn't like you could call or could go into a courtroom and send a SWAT team to your house. And they say, I haven't heard about that in the news. I don't believe that because I haven't heard about it in the news. And I'm going, you have to read the bill. And hopefully there will be some more interest on that. But we can see some meaningful consequences of these kinds of views as well. And just recently I've been talking a little bit about Mr. Khill, who, if you're not familiar with this story, basically he heard noises outside of his house and he stepped out with a shotgun. And he saw somebody who was breaking into his truck. And there's one story on this one, so it's basically his side is what was communicated to the court, but he says essentially that he saw this guy rummaging, he told this guy to stop, and the guy spun around and had his hands to his chest, which Mr. Khill thought he had a handgun. And so he fired twice, and the other individual was killed. And so at his first trial, he was acquitted of his charge of manslaughter, which in the US would have been the end of it because they have stronger double jeopardy protections than Canada does. But in Canada, the Crown gets to appeal. And so they said, we're appealing this on the basis that he should have never gone outside. He should never have confronted this guy. We want to have that communicated to the jury, that the jury should consider whether his decision to step outside of his house was, part of this transaction. Which is interesting because we do actually have sections of our criminal code that allow for defense of property. You're allowed to defend your property with reasonable force, which the courts have said is not lethal force, but many cases in the past had said can include being armed with a firearm. Because if you go out to tell that guy, hey, stop breaking into my car, and he has a screwdriver, which he did, that can cause you a whole lot of problems. It is very difficult to continue being alive if somebody stabs you repeatedly with a screwdriver, which happens. So we get into this weird place because you're allowed to go out and protect your property by saying, hey, go away. And you're allowed to protect yourself, except that the combination of doing those things gets you to a place where you're not allowed to be, apparently. This is in contradiction to some recent cases, including some famous cases. Gerald Stanley, everybody remembers the Gerald Stanley trial. Now, Gerald Stanley is not a self-defense case, notwithstanding that people sort of talk about it. It's a malfunctioning gun case. But the Crown and the defense in the Gerald Stanley case agreed that it was reasonable for Mr. Stanley to go out and confront people on his property, and that it was reasonable for him to be armed with his handgun in the process. So that was not considered part of the whole issue. The issue on that one was he being accurate when he said that the gun went off in his hand? So when we take this back to Mr. Khill, that went all the way up to the Supreme Court. Who knows what the Supreme Court costs if you're paying for that privately? Just fighting your way up there. Not millions, but we're talking six figures. And for a lot of people, that's most of the money that they might have available. And that means mortgaging your house and so forth. And then he gets sent back for another trial. And that trial results in a mistrial. Well, guess what your lawyer charges you when you have a trial that goes to a mistrial? Full fees for the trial. I've heard nothing, but it's full fees for the trial. Why? because the lawyer had to do as much work getting there for that trial and can't use any of those days that were, other than maybe for catching up on paperwork. So we're talking about, we'll say $100,000 to get up to the Supreme Court after the whole thing. Another however much for his second manslaughter trial that ends in a mistrial. And then he has a third round. So even if he wins at this point, he's out tremendous money, but he does not win. At the third trial there, they convict him on the manslaughter, and he was sentenced to 8 years. The judge very much wanted to make a point of this. Now, the mandatory minimum, given that there was a firearm involved, is 4 years. That mandatory minimum, by the way, would not have been triggered if he went out with a chainsaw, or if he had gone out with, say, another, any like a combine harvester. There's all sorts of things that he could have grabbed, a chain, a fire axe, any of these things. But because it's a firearm, that triggers a 4-year mandatory minimum. But they gave him 8 years. 8 years. And so a lot of firearm owners and a lot of people just generally. I've heard from a lot of people who aren't firearm owners who were quite concerned, going, wait, what do you mean I have to, what am I supposed to do here? And it's clear the answer from the courts is let the guy steal your truck, which we'll come back to. But so he gets that 8 years. Now, Mr. Khill made a very terrible error that night, and that error was probably talking to the police. Because had he not, he might have been in a much better position at trial. But that's the situation that we're sort of looking at there. And where we come to on this is, again, a place of confusion. And what I mean by that is that we have courts who don't really understand what it means to call 911 in a rural community. Because if you're ever in a rural community, what's your 911 response time? If you are being murdered.
3 hours.
3 hours, yeah. And that's like, if you are being murdered. In fact, right now, here in Ottawa, if one of you picked up a chair and decided to start beating me to death, we could probably get a police officer here in about 10 minutes. And I can tell you, I don't think I would survive 10 minutes of chair beating. I've seen criminal files. I know what that timeline looks like, and it's about a minute. So, yeah, we're expected, therefore, to call 911 by people who are the most able to expect that 911 will serve them. People who usually live in, in towns, and also have their names and addresses plugged in on police computers as very high priority, drop everything. If this person calls the police, you get there no matter what, which I don't have on my police entries. I'm guessing you don't either. But also people who just have the luxury, for instance, of missing work, which is a tremendous luxury for, in the sense that if you are a farmer and your truck is down, all of the things that need doing still need doing. You just can't do them. And there may be incredible consequences of not being able to do them. Animals dying, these sorts of things. These are, the whole thing of just call your insurance company, just call 911. I can tell you right now that even in Ottawa, if I went out the back door right now and started stealing somebody's truck, the police response time would probably be measured in hours, not minutes. And that's if you saw me there currently stealing a truck. We get into this place of disconnect because people expect that they're able to take meaningful steps to protect themselves and their property, and they can't. But this is part of what all of this is aimed at shutting down, is not just self-defense, but also the culture of sort of self-reliance, the culture around all of these things. Because what they're trying to stop isn't just people owning guns now, it's people owning guns in future. They want to make it onerous to hunt. They want to make it onerous to do things like, 3-gun matches. And I can tell you right now, I'd rather be at the 3-gun match because there's a battle for Alberta in Edmonton. but I came here to talk to you guys. But these kinds of things they want to shut down because they're worried that people will get into guns. And they're worried that that will get people asking questions like, hey, do I really think that it's appropriate that people are going to jail like Mr. Khill if we're in a situation where I can tell you if a police officer had testified that the suspect, upon being told to, drop what they're doing, had spun around with their hands at their chest, I could not see a police officer getting convicted in those cases. I wouldn't see it. But people say, call the cops, this is going to be the solution to everything. It's not always the solution to everything. And we're in a difficult place. They want to make hunting difficult. The police, notwithstanding the fact that they don't say it, and the RCMP are driving a lot of these bans. If you see the SKS end up on the ban list, it's because the RCMP put it there. The RCMP has had the SKS on their sites for a long time. Why do they have the SKS on their list? What's that? That's part of it. It's because there's a lot of them specifically on reserves. And the RCMP does not like people on reserves with firearms. It makes them nervous. Because the RCMP has some systemic issues, but that's why the SKS is on that list. Notwithstanding the fact that the SKS is a very old gun that is not exactly, they'll call it, when they put it on the list, they'll call it a weapon of war, which was accurate in like 1950. But, what's that?
1939.
Yeah, it's, nowadays we expect a detachable magazine and not, not fed with a clip. And here I'm being particular as to my definitions of clip versus magazine. But that's why they want it on that list. And whatever firearm replaces the SKS on reserves will end up on the RCMP's next wish list. Because notwithstanding the entry that they put in on C21 about this is intended to respect the rights of Indigenous people, Indigenous people are specifically on the RCMP's target list here. But so is everyone else. They just want to make sure essentially that people are not able to rely on themselves, not able to do any of these things. And from the position of the government, I think that that's in large part because they're concerned that when you get somebody who gets interested in guns, they stop being interested in the Liberal Party. There is a major push to sort of shape culture that we're seeing here, and it's concerning in that regard. A lot of the bills that you can see represent a big effort to change how people think. Bill C11, the various bills about controlling the media and the internet are really intended to shape what you see and who gets to talk to you. So I guess sort of to bring this around full circle as to why I keep making videos and why I think it's important to do so is we need voices that aren't coming through that lens. With Jody Wilson-Raybould, when she left the party, she had recordings where they promised her that if she did what the Liberal Party asked, which, with the whole SNC-Lavalin thing, that they would provide her with media cover. They specifically promised that the media would speak well of her through editorials, through friendly puff pieces, through whatever, because that's where we're looking at here. So anybody who they can't call up and say, hey, we'd like you to change your mind and we'd like you to change what you talk about, those are voices I think are important to keep going. All right, so I guess that's my time here. I can go on forever, and I have a tendency to do so, but I will open it up to, I'm guessing people might have questions.
If you all remember, when we were fighting against the two amendments, G4 and G46,
yep.
We made a claim which, it was labeled to us, made a claim that G46 didn't include all of the firearms that were in this section called including. So the 10,000 joules, I think you addressed it, but just I want to be super clear. So when they said all firearms that can generate more than 10,000 joules of muscle energy, including the following, when you pick up one gun, which was a 1908 Brazilian Mauser, that was only designed with one cartridge whatsoever, which was the 7x57 millimeter Mauser, I believe. That says including this gun.
Yeah.
So that would have been prohibited should that have become law. Am I, in your opinion, I'm not asking for a regular opinion, but am I right or wrong? Would that have been banned?
That would have included every one of those models. Like when they put the Ruger #1 on there, it doesn't just include the large caliber version, because they are now defining that. It is legally saying that the Ruger #1 is a gun that shoots 10,000. So every Ruger #1 would have, the way the courts would have interpreted that through, like, you know, longer than I've been alive of statutory interpretation, applied across cases everywhere in a wide variety of fields, that would have been defined as shooting over 10,000. When you see the government say in the Controlled Drugs and Substances Act, they say, you know, all sort of opiate derivatives, and I forget, I don't have the exact language memorized, and then it says including. You cannot go into court and successfully argue, yes, I had one of the things that is included in that list, but it doesn't meet the criteria of the top sort of level thing. You would not be in a position to say, listen, my Ruger #1 is 22 LR. The courts would say it's specifically on the list. And in fact, not only this, but the government of Canada, the federal government, agrees with this. And what I mean by that is that they have put this into court filings. They have been arguing the opposite in court, which their lawyers have an ethical obligation not to argue BS, right? They have an ethical obligation not to argue not law. So clearly they think that this is the law. And they have said, with regards to the AR-15 bans, you know, which said AR-15 and all variants, including, they have said that if you have something that is specifically on that list, it's not open to you to argue that it's not an AR-15 variant, because it's specifically noted, and that means it's an AR-15 variant, even if your gun is, you know, the 𝐂𝐂𝐿 single shot. If they listed it as an AR-15 variant in that category, then it's an AR-15 variant in law. So what they're telling the public and what they are arguing in court are two different things. What they're arguing in court is exactly what you're saying there, is that once it's on that list, all models are covered. So.
Well, and it's fascinating, right? Because the government has lied completely nonstop about that the entire time. The RCMP issued an opinion, the RCMP, not lawyers, right? Issued an opinion that, you know, the 1908 Brazilian Mauser would not be banned, even though it's there on the list. And of course, the media, even though I've explained virtually what you said, two journalists, they turn around and write a story saying that's CCFR misinformation, Govt misinformation, that all of those guns listed on the list would be prohibited should that provision become law. Isn't that amazing?
I don't think it's controversial to say that I don't think you could find a lawyer who would read those provisions and come to the conclusion that the RCMP have, or come to the conclusion that that's been put out as liberal messaging. And when you see it in the media, it's really, you know, as I mentioned, they have great sort of media influence. You're seeing a lot of that messaging being successfully put forward, but I don't think, like, there's times when I say this is my interpretation of something, this is my impression. This is one of those places where I just think it is, it's an unquestionable aspect of just how this is interpreted. I mean, I would certainly argue it if I was stuck with it and say, like, look, this is what they're saying, but I don't think that would actually fly. I think the court would say, listen, this is clear and unequivocal, that there's just no wiggle room here, there is no space. So, yeah, that's why I say that this one, sometimes I think that they're wrong about their legislation. This is one of the places where I think they're being dishonest about their legislation. It's either dishonest or incompetent to a level that is shocking. Those are really the options. It's like if somebody goes and, you know, tries to sell you a Pinto and they say it's a Ferrari. Like, well, either you are so ignorant of cars that what are you doing trying to sell me one and making any claims about it, or you're just lying. It's, those are the only conclusions we can get to here.
Well, thank you for answering my question.